Hi there, it's Billy Tarasio from Modern Law Practice. And today we're going to talk about ethics and the modern law firm. So, Chad and I were recently in the Dominican Republic and we were speaking with the American Bar Association's family law section, and they are an amazing section. And so, if you're thinking about a section to join, these people have a good time and they know how to pick a great conference. So we went to the Dominican Republic and we had to talk about ethics. And you know that I talk about law practice. I talk about how to run a law firm. I talk about real issues that face law firm owners. But I don't always talk about ethics. And when I see ethics presentations, most of the time I don't like them. And they just tell me what I can't do. And I am an experimenter. And I am someone who wants to do things, not be told I can't do things. So I find many ethics presentations to be frustrating. And when I am talking about ethics, I'm usually talking about changing the ethical rules to make them more favorable to business and business owners, and I think consumers. So when we were given the job of presenting on ethics, it wasn't exactly easy, but we did it, and we managed to give a presentation that is, it was very, very well received. And so I wanted to share some of it with you. Not going to, of course, bring you through this whole thing, but it's called Ethics and the Modern Law Firm. And here's the starting point. We know that in order to be competent attorneys, we need to keep abreast of changes in the law and its practice. And we stay abreast of changes in the law. We do a really good job with that. We know when there's new case law. We know when the statute changes. We know when the rule changes. But do we keep abreast of changes in its practice, in the way that law must be practiced? If we were to go to a doctor who was using the same techniques to run their office now as they were previously, if they weren't using the latest technology, we probably wouldn't be satisfied with their services. And if we lawyers are also practicing the same way that lawyers practiced 30 or 40 years ago, we probably are violating Rule 1.1 on being competent. And then there's this. Comment 8 to Rule 0.1, saying lawyers should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. Now, most of the time, we focus on the risks associated with relevant technology, but the benefits are huge. The benefits are absolutely huge to lawyers. I want to go ahead here to Model Rule 7.1. Which is really great and something that you should take a look at, and really helps shore up why it is that you should pay attention to what it is that you're saying about your law firm, because it really does need to be true. And in order to be true, in order to be absolutely accurate, you really do need to know who you are. And then there's Rule 1.6, which tells you when you must withdraw because you do not have the capacity to take on any more work. And how many of us really know when we've hit capacity? One of the things that we've really focused on in my law firm is figuring out, okay, how do we evaluate the capacity of our lawyers? This is important for me as a business owner to know what the production availability is, but using data really helps us to do that. And then there's this. Model Rules 5.1 through 5.3, which require that attorneys provide adequate training and supervision to ensure that the behavior of your lawyers and non-lawyers conform to the ethics rules. That means you have to have policies and procedures and training and management in place that make sure that your firm is running ethically. And there's simply no way you can do this without having a practice that's run well. And so that was the crux of our argument in the Dominican Republic. And that is the crux of my ethics presentation for you, is that you should rethink ethics. You should rethink ethics as to the way that they require you to keep up. They require you to run a healthy business, because if you don't run a healthy business, you're going to end up in trouble. And one of the stories that I relayed is something that I heard recently from a pretty powerful woman who works as a lawyer in the nonprofit world. And she is committed to building sustainable law practices that can make a difference to the community. And I just love that so much, because we think that money is maybe a bad word, or that it's a profession. Why do we even care about how your business is run? Well, if your business isn't run well, you're walking an ethical tightrope. And she gave a story of right out of law school, she joined a law firm. It was a nonprofit, and it was highly respected within the community for great legal work. And when she walked in, within a few weeks, she found out that more than $60,000 had been embezzled, and 3 lawyers had mass exodus. And now those that were left had more cases than they could possibly take care of. So they were looking at violating duties of communication and competence and 1.6, which requires you to withdraw if you're over your capacity, if it would be required for the mental, physical condition of the attorney, and of course, the violation of the safekeeping of property. If you don't have a well-run practice with a strong foundation and policies and procedures and actual information through data, you probably are walking that ethical tightrope, and it's just a matter of time before your people leave or somebody steals your client's money and you're on the hook. Not only do you owe these people their money back, but you've now committed an ethical violation. So please, 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 if you're one of these lawyers that thinks that it doesn't matter how you run your firm, rethink again, check it out, check out the talk, check out the model rules, and think a little bit more about how you can make your firm a little bit more ethical and a little bit more profitable.